debtors a lapse and what is pending. That is a major thing. Mostly that is where that is a tricky part. They never disclose. Even they themselves don't know what are the you know. So once you know, you will know what is the exposure. Rest is all in paper. Rest is all accessible damages or accessible thing. What will be the most crucial thing with respect to these companies would be the electricity, fallouts, the tax fallouts, the pollution control board. It's a huge amount. Pollution control board sanctions, very huge amount, and also environmental clearance. Other than the pollution control board, there is an agency. So these exposures has to be completely assessed. I mean, that's what I feel. I thought should. I mean, just anybody, nobody said it, so I'm just saying since I'm hearing.
And adding on to you, Ambili ma'am, that this being a foreign investor,
Mm,
uh, whether because of what you just said on the
mm,
tax side, on the pollution side,
mm.
would they be ready to invest in a equity or debt? That would be a consideration for the investor
Exactly.
to take
Exactly.
a call on.
To for them to analyze that, they need to know what is the actual exposure when it comes to statutory non-compliances and
Yes,
penalty pending.
and
Mm.
because the law of torts is very liquid, I mean, not very hard and fast in India. But
Yes.
if it is a US investor and someone gets some
Yes.
sort of an issue with the company and they're into equity participation, that
Yes.
company can get into trouble in US.
Yes, because I have handled something like this, so I know this fact for sure. Something from Tirupur. There was a foreign investor a long time back, and he was stuck because he didn't know how to get over. And you know, in India, it's not easy to, understand. They will say
Yeah.
everything is sorted, but
Yeah.
that is the real thing. That is the thing that you really need a due diligence when it comes to buying out a company, especially a cloth garment company. Mm.
And on
Uh,
the
may I
Yeah,
may
someone
I
is
add
trying.
the
Yeah,
yeah
please, Satish ji,
yeah
yes, go ahead.
so yeah yeah so looking
Just
at
a
the
moment, Satish ji. By the
okay.
way, Chris and Linda, this is Satish Kumar Gupta, our associate, colleague, and friend. And just, yeah, Satish, you can go ahead.
All right,
we
sure.
met
Uh,
before.
before looking at the target, uh, uh, what is important is to look at the underlying business of the company. Now, it has been mentioned that it has got dyeing facility as well as garment. Now, and also it has been mentioned that facilities of the companies are more than 10 years old. Now,
Hmm.
in these kind of industries, the technology changes very fast, and new machinery comes up, which has got high productivity, which requires less manpower, and that is why uh, modernization of the textile companies. So that is very much required. So if the plant and machinery is not that productive, so I believe that the underlying business will not be very profitable. So that is very important to take a look at the plant and machinery, how vintage it is, and what is the productivity of these machinery. And we have to benchmark it with the machinery which is currently available.
Hmm.
So that is the first part on the plant and machinery. Whether see, it is like a kind of situation of uh, buy or buy this kind of plant or set up a new plant.
Hmm.
So essentially, looking at the plant and machinery is very critical for a this kind of industry where technology changes very fast. Secondly, dyeing is very pollution oriented, and that is why dyeing process is generally shifted to India and Bangladesh or these countries, and it is not done uh, in Europe or US. Uh, Now, if the company doesn't have pollution control and other and the modern facilities, then if the company is becomes the owner, then the responsibility for the polluting uh, that kind of liability will become the new owner's liability. uh, and generally, uh, what we have seen, yes, Indian promoters are fine with ignoring that kind of liability. But yes, foreign investors, no, it is complete no. They won't like to uh, get into this kind of liabilities where they are responsible for any pollution or any safety aspect, and all that. So these are the 2 points which I have to make in respect of the underlying business, that is a plant and machinery which the company has uh, in this kind of industry. And also, it has been mentioned that company could not operate at the optimal level due to very high attrition. So that clearly means that company required some requisite or skilled kind of manpower. That is currently available or not. I think that is something which is very very important to find out, so that it in future the company doesn't face this problem, or if faces this problem, the cost is not very high.
Yes,
That's
Devang.
my end.
Sir, I wanted to say something.
Yeah, Devang.
So let others complete.
Okay, Pang is
Okay,
saying
okay.
something.
Kantiji, you start. You please go ahead. Go ahead.
So one, I think I disagree that the Indian investors do not look into the environmental concerns. The DD is important, and every acquisition that I have done, for whether it is an Indian client or overseas client, the environmental factors are very, very important. Two, as I stated in my chat box, we need to see how the retrenchment was done, that 20% reduction of the workforce, and what are the long-term liabilities, if any, in respect of the outstanding workmen liabilities, and whether the retrenchment of redundant manpower or obsolete manpower can be is a. The third thing that is important is to see into the tax liabilities. Are there any tax liabilities that could be of concern for further operations of the or restarting of the full-scale operations? I think those were my three fundamental things.
Yes,
Mr.
Devang.
Devang can take over from now.
Okay, so
Devang
the
is
point
also from
was
our team. Yeah, please.
right.
Please.
For Kanti, the point was essentially on that, Indian promoters who are running, they may not be so much affected by the pollution concerns and all. But yes, investor would obviously, who is taking over the plant, would be interested in doing that due diligence.
In fact, the question which first I would like to put to the investor is, when the options of Vietnam, China, and other countries are available, why does the investor want to come to India when anti-dumping duty is imposed upon India? First question. Second question, I would just like to add all the questions. What is the lucrative point? The machinery is old. It is having environmental issues. It is having labor issues. It would have many other issues which are including workforce turnover issues, single client dependence issue, and even that client may go away due to anti-dumping duty and the cost disadvantages. And the land is in rural area. So why is the investor investing into such a company? So that is the first question, which what is the strategic advantage that the investor is having to invest in this company? So of course, many questions can be asked from the target company to the target company, but this is one question which target company should also think about of asking to the investor. It makes no strategic sense for that investor prima facie to come into and buy this company. Plus, there will be many compliance and other issues. So that is one aspect of due diligence which has to take place on other side. The entire list of litigations has to be there, of which this company is facing, because the company seems to be in stress. Another point is maybe the huge liability, what is the financial position of the company. And when the company is in such a position, why is the investor coming and buying this company directly from the promoter? It is a huge possibility that they could buy out the company in a safer manner from my institution or through some another source also. And they are listed foreign companies, so they'll be having sophisticated investors also. So investigation from one side, of course, due diligence from one side has to happen, but from due diligence from another side also has to happen. That why this investing company is investing into India, which is my understanding. Otherwise, a transaction may fail if there's no strategic, maybe the strategic advantage to both the companies.
As an
Yeah, so
investor, I can answer to your question, Devang. It could be anything. Probably they are thinking of buying a company at a very cheap cost, getting the distribution network and the client base, getting a turnaround expert in, turning around the company to a better working arrangement. Because they're buying it very low, they would be buying it very low if the machinery is very old. They bring in more technologically sophisticated machinery to increase the quality of the product. But there could be any number of reasons for an investor getting into this sort of a situation.
and it's a very good challenge to provide, because it's adding value, and it could be that they just want that one customer, or and it may be that there's a brand associated, and as you say, it may not be worthwhile taking the liabilities to balance that up. So it might be worth doing an asset purchase for just those. Of course, the client contract would then need to be novated over.
Do we know who the one customer is? Are they from India or overseas?
So,
I think we're assuming abroad.
Dr. Spedding, what would be your take on the environmental issues that might crop up in this specific case?
Well, they're overwhelming. Basically, obviously, the fact that they're in the clothing manufacturer, there's the carbon emissions, there's the water issues. I mean, dyeing clothes is like with agriculture, it's a massive environmental exposure there. Then we have also the whole idea of ESG, but all the facts raise red flags on all of those. And so therefore there would have to be, the point is, any company coming in from overseas wants to integrate ESG due diligence. So so some of those questions, a lot of the questions that have been raised will actually come up within the scope of an ESG due diligence. And now, of course, depending on whether this investor hopes to sell on later, Rocky, and it's very important, and have a position in India, that's great, and a distribution network, but also have a value creation to turn this around so that it can then maybe attract other investment. So as you've said, the liabilities hit that investor immediately, as on this new directive. There are it's the supply chain. So there's a huge, I mean, many. The fact, as has been mentioned, the equipment is out of date, not being cared for. Possibly the workforce claims. Possibly there's a massive amount of legal claims that could have happened and are ongoing, as well as government liabilities. So we'd have to do a very detailed ESG and other due diligence. It's a kind of a storm there, I would say. And so yeah, it's a great exam question. And I think that it's perfect for, if you look at now in the world, the global trends are in favor of ESG, and investors, 80% I believe of investors are looking for good ESG performance. This company, as the other person said just now, we have to see the strategy of the foreign investor. What is their overall purpose in coming to India? Because the location may be a very key thing too, and as you've said, getting it for a very cheap price, but versus the liabilities. So I think the environmental implications are huge, actually, from the facts as we have them.
But
Is
does
that Huh?
but does ESG non-compliant company will affect investors coming to India?
More and more it will. Yeah, it will, because but it's here. I mean, this new directive which affects Europe. We're talking here, aren't we, about Europe? They want to the larger companies is in 3 years, and then from 4 years. So companies will be planning ahead on that. So yeah, I think it's getting more and more. It's having more and more of a practical bite. Yeah.
But Linda, coming back to you with a counter question. You remember that bamboo project that we were working upon?
Yes.
That the investment didn't come for that as well. It was a completely green project.
Mm.
So how do you see that project in relation to this project? Probably what I think is that the difference may be that this project is commercially viable in terms of investment, and that project, which was completely green project, was not commercially viable initially in a short term of 5 to 6 years.
Mm. I think that the bamboo project was potentially too early, Rocky. You know, because I mean, they're still looking at. It's not stopped, but they've paused. I think because when we did the market research, the market didn't match with what they want to do, which is change the whole possibilities on construction and infrastructure, and that is happening in Philippines, funnily enough, now, but it's taken an awful long time. You know, so
by the way, this project was meant to replace steel with bamboo in construction projects. So this was very different sort of a project that we were running at that one point in time. Anyway, so coming back to this project, yes,
Rocky, may I add here from my practical experience in textile industry?
Yeah.
So as Linda has mentioned, and you have also mentioned on the compliances and ESG issues. So I have the practical experience of running a textile company, which also had this dyeing facilities after weaving, and also they had also the accessories, buttons, trims, and okay, and uh, uh, cloth, woven cloth, and these accessories were supplied to international clients, Gap, and Selected, and so many other international buyers. And these buyers, they have the systems that unless that operating unit is compliant with the local laws, they will not buy from you. In fact, their team will visit your unit. They will take that compliance report that all your workers' dues are paid, their provident fund dues are up to date, gratuity is paid up to date, okay, all, and also the pollution facilities and all that are up to date. Only then their supply chain will approve you as a vendor.
Yes.
If there is any or in addition, there are no child labor
slavery
employed. So there are a lot of checks and balances which reputed buyers and their supply chain team assess and they assess the vendors, okay, on these parameters, only then they approve. So we had a lot of difficulty because our company was in insolvency, and that particular unit we have to ensure that we pay we make up to date all the payments to the employees in that particular unit, so as to keep the compliance active, and so that they continue to be on the vendor list.
Sir, I may add here that not only this is part of the due diligence, but these are essential obligations of the vendor in a vendor contract with international suppliers.
Yes. Yes, Devang, you wanted to say something?
Yes, in fact, Satish has brought in a very important point of child labor, etc. Plus, the most favored nation status which was given, a preferred supplier status which was given by USA to India, is now stopped since couple of years, and it has gone to Bangladesh. Bangladesh still continues. So, if I was an advisor to the investor company, I would have suggested to look at Bangladesh, neither China nor India nor Vietnam.
Devang, I need to counter you on that. December, January, I was in Bangladesh looking at one unit of manufacturing unit, and I was supposed to meet the Bangladesh Garment Manufacturers Association, and I got a shock of my life that I came to know that the Bangladesh government had increased the minimum wages, and almost, I mean, when you talk about a facility or a manufacturing facility in Bangladesh, it's very huge, spread over 2 to 3 acres, with millions of clothes being built, being manufactured there, and almost 500 of such units in Bangladesh were going insolvent because they cannot sustain the increased wages. So Bangladesh, as of today, is now on a very difficult situation, in a difficult situation as far as the cost benefits that they had earlier now has been removed from that cost benefit thing. And the thing again has jumped up back to the Chinese that they can do better thing and a better quality.
Thank you for updating me.
So for the insolvency professionals, this is a very good opportunity to learn about due diligence. Every IP needs to get, I mean, they do it without even thinking, they do it. They will tell their staff or their team members to do and find out about the. Yes, Ram, please. You have a question or you want to say something?
I just, I mean, I think there is in a very short time, lots of points have come up. What I just tried to is to put headings. If we have to put various points only under the headings. So first is the strategic fit, which we have to look into. Then the main issue identification and how many of those can be resolved. An elaborate statement. That issue identification should span the HR issues, the workman issues, and also the litigation, the tax issues primarily, and then the investment size, and then the utilization of the investment, then the business diligence, financial diligence, legal diligence, HR diligence, and the final view on the statutory risks and other things, penalties, key employees, and the arrangements with them, and then the cost savings in the base country of the investor, if at all this deal is going to go through, the cost savings which the investor will have in in sourcing the production from India is something which they can look into, and support, if any, from the government is because the investor is trying to revive a company. Then the ratios, like important ratios like ROE, ROC kind of thing. And then the background of the promoters and their continuity post takeover are some of the things which I tried to put in the form of headings actually. So this is from my side.
Okay, one question to Satish and Devang. What stops us from taking over this company after this company gets into insolvency at a very lower rate? Any thoughts on this?
In fact, I would have preferred that rather than buying in this port first, either through SARFAESI route or through insolvency route. I would have preferred to buy this company at lower price, I would have preferred insolvency because you would have got a clean slate. Of course, the clean slate theory also has come in a big way to Satish ji. So we thank him for that. So I would have preferred that and then turn around the company whatever way we want.
Yes, Harshaditya.
Yeah, hi, sir.
Yeah.
Hi.
So I just have one input on what stops an investor from getting into buying an outer insolvent company. It stems more from practical standpoint. So actually, one of our clients actually did buy a company under insolvency, and they thought that they got a good deal. But turns out even the local municipality and local authorities were not well versed with the insolvency law, and that it supersedes all the existing regulations. They wanted their dues to be cleared by the new investor before even starting the operations. So to and fro legal hassle, even after buying out the company, they were not able to start the operations for almost 1 to 2 years. So
How long was this? I mean, how long back this thing was?
I guess this was a year or two ago.
But then insolvency courts normally direct the government departments not to harass or
That is
trouble
true.
the
They even
resolution
got a
applicant.
direction from them.
Yeah.
But as you know, government officers in India,
Yeah.
they were elected, and the clue was give us pay us back, and basically line our pockets. Else, no regulation can stop us.
I think buying it in the insolvency in this specific case would be a better option, because then, as per the resolution plan, you can waive off the liabilities that are there.
That is exactly what we did, sir, and they got it in insolvency as well. It got it approved by the court.
Yeah.
But the problem that I'm sharing is more of a practical.
That is an operational issue that can be sorted out. See, when you are saving money on buying a company which is so down and under in terms of all sorts of compliances, be it environment compliance, be it commercial compliance, I think buying that sort of a company within an insolvency scenario would be a much better option, because then you don't have the liabilities, because there would be many government liabilities also which would be coming along with that, or like Christopher said, only by the assets, which nobody would want to, because all the assets would be under the bank's mortgage.
Right. So yeah, one of the practical issues that investors have faced. So just wanted to highlight that.
So just one point, we are speaking too much about India, but this government issues and all these issues are all over the world, not just in India.
Yes. The only thing is that in the developed world, they are structured. In underdeveloped countries, they are unstructured. India is a mixed and hybrid mode, where some departments are very structured, some departments are very unstructured. So, like at a local level, at a state local level, people would not know about the laws. Departments would not know about the laws. So, there would be an additional effort on the part of the resolution applicant to move the court to get some sort of a direction to, and those directions take time to come.
Gupta ji,
Assume-
there's a doubt I need to ask.
Yeah.
See, this particular company who is investing in our country, a relevant question which came to my mind is, are they going for any, financial, loans or something from, I mean, that will be a good question, because then
Yes.
the scenario absolutely changes. Because, to get the loan, if they are financially funding the entire thing themselves, then it is a different thing. But if they are going for any financial kind of support in their country of origin or elsewhere to buy this, then there are a lot more challenges to, statutory challenges
Yes.
when they are buying,
Oh.
even an insolvent company. Because one of the matters I remember, there were there there was an order. I mean, the resolution came through. NCLT gave an order, but what happened is only few properties were in the company's name. The rest of the properties were in the guarantor's name.
Yeah.
These guys were never informed that it was in the guarantor's name. And finally, half of the originals were not given, and they're still hunting for the originals because the loyalties and all these properties lay in very interiors of the country. So the loyalties lay elsewhere, not with the company. So I think these are the questions also. I thought maybe, I don't know, it could be relevant.
Whenever an investor would get into this sort of a project or any sort of a project, there would be 4 basic due diligence that they would be covering. One would be the financial due diligence. There would be a legal due diligence. This would cover all the properties and all. There would be a commercial due diligence, whether the project is commercially viable or not. And there would be an operational due diligence. Over and above that, if he's looking at if the facts are uncovered in all these due diligence regarding some properties which are under guarantee or something of that
Yeah.
sort, they
Yeah.
would even look at some sort of an asset tracing process where they would trace those assets. But yes, what you just said is very true. 8 years back, I was in Guwahati tracing 60 trucks, which were all, I mean, it was a 4-wheel drive truck, which costed 60 lakh of rupees or 70 lakh of rupees in those times, which were used to transport coal from the coal mining facility to some other place. And they were very huge trucks, 60 trucks. The bank, and I was there for the corporate data, and they wanted to seize those trucks. We took them to the trucks, but they couldn't seize the trucks because they were in the Ulfa area, and they were just told, I mean, you will be killed if you even touch those trucks, and they couldn't do anything about it. Yes, Devang, you wanted to say?
Yeah.
Yeah. Chris, just a moment. Let Chris comment. Yes, Chris.
No, please.
Okay. Yeah, Devang.
I just wanted to add the compliance issue would not only be in direct investment, even if they come through a financing route, they'll have to comply with ECB norms. And if they come through equity route, they'll have to comply with ODI norms. So whichever route you come, you have to comply with the norms that is required. And yes, you can invest directly. There is a free route without permission, etc. But there are certain restrictions in either way.
Okay.
Chris?
But I mean, Rocky, how did you get around with about the 60 trucks and the assets?
Linda, I was for the corporate data, so we just handed over the symbolic possession
Most
to
easier.
them, and I'm done and dusted with. It is the problem of the bank, not mine.
I see.
Yes, Chris.
One of the key assets, let's assume, is likely to be this major customer. And as many of you will have experienced, as the buyer, you want an introduction to that customer as soon as possible to ensure that they're going to come with a transaction. Because even if there's a longer term contract in place, if the client or customer wants to get out of the relationship, then they will, right? So this is always the delicate dance. How far down the commitment by the purchaser will the vendor allow a meet with the client to assess this? And then on behalf of the purchaser, does one try and enter into some sort of documentation of the purchaser to get some confirmation around that? So we've got, I think, 25 minutes left. Perhaps we could just list out a few things that people might want to cover. I mean, one of the things I'd like to spend a few minutes talking about is liaising with the liaison between financial, legal, commercial, and operational DD. So if all of us here were working for the same purchaser, what I would propose is that we prepare a master terms of reference, a bit like we saw earlier, and then a list of areas of activity and who's going to do what, so that for each of those headings, it's agreed that we'll do the things that we bring without overlap. This isn't often done, but I think it brings a lot of value. Anybody got any comment on this sort of approach?
This is going to be helpful in creating an IM for the investor, the information memorandum for the investor, because you need to list out all the responsibilities, liabilities. You need to list out all the assets that are there and what are the hindrances to get those assets. So information memorandum would be very easy to make after we have gone through all these four sort of due diligences.
What else would people like to cover in the remaining time? Any just throw out anything that you wanted to raise. Let's just sort of use the opportunity to share views on things.
So I would say that very importantly, the first aspect should always be the financial due diligence, because if the company is not financially viable, then there is no point going ahead with the other due diligence. Probably someone might have a different view on that. All are chartered accountants, so probably the first part should be the financial due diligence so that they get their first fees immediately. Am I right? Yeah, Devang.
Sir, I have a question. I don't have an answer to your question, but maybe after your question is answered and further points are taken, I have a question to the learned speakers, that in countries like Russia, which are socialist countries and not having maybe a legal and regulatory regime like Europe or USA or a democratic country like India, how do they conduct their due diligence over there? If they could share their experiences.
Yes. So one always needs to be working with local lawyers and accountants, so who understand the subtleties of these things. And so although one can bring a structure such as this, it will always need to be amended to suit those sorts of requirements. So yes, as you say, in countries such as Russia, where I don't think many people are investing anymore, you basically take what title you can to the key assets that you're looking for, right? And we've found in some countries, for instance, that you have to make an allowance for they call it wastage, right? Where there's some sort of corruption that goes on within a business. It might be theft by employees and so on. So these things often need to be factored in, but whilst also complying with local and international laws.
In terms of if it is an asset-based business or a company, I would not get into Russia. But if it is a trading-based company, I would rather have an offshore company with a subsidiary in Russia, but having assets within Russia would be a big liability, because anytime there is some sort of an issue within Russia, I would be losing over on that asset.
Yeah, I have one very important thing while selecting the lawyer. Actually, you see, when in jurisdictions where we don't have operations or we have very less knowledge, it is important that you select a lawyer through your regular international lawyer, because that is very crucial. Otherwise, there is a chance that the local lawyer, for example, China. So there is a chance that the focus will be mainly to support the local person. So it is very important that you select the lawyer through your regular attorney, where there is an answerability and relationship kind of thing, actually.
Yeah, you're very correct, Ram, on this. And China being a civil law country, there is not many lawyers there.
very, very difficult. We have experienced in my previous distance also very big issues. Though the local company is wrong, the courts and also the lawyers were mostly in their favor. Primarily, I mean, it may be that, because of the local feeling, or maybe they are also under compulsion. Sometimes, we don't know, because they are under compulsion actually, because if they disclose all the facts and support the international party, then they may end up in a problem. That is also there.
I would like to add here one more dimension to the from the investors' point of view. One is how attractive the target is essentially. That is what is the value we are providing for the uh, target's asset. Secondly, any investor would also like to assess how much investment, that is the incremental investment in new plant and machinery, upgradation, more modernization, or working capital, it will have to invest. So it is not only the amount which is paid out to the target, plus also additional investment to make it a viable unit. So that is and that is what the investor would like to assess as a whole, as a composite proposal when it decides to invest in the company.
Yes, Devang,
Can I raise a question, please?
please go ahead.
See, we have been talking about due diligence for last 1 hour, and many experts are there. There's that famous dispute going on between Daiichi and Ranbaxy, which is with regard to the due diligence and appropriate reps and warranties. Any takeaways that these experts can share with us from the Ranbaxy Daiichi dispute in relation to due diligence?
I do not have any knowledge about this case, so I will not be able to comment on this. Anyone who has some sort of a knowledge on this matter may comment. Otherwise,
Ranbaxy Daiichi dispute I'm referring to.
Yeah, it was I mean, immediately it cannot. I think I cannot answer also, but I think it was the largest acquisition. It was something like $5 billion acquisition. It was a large acquisition. Yes, I do remember vaguely because I was an Orchid Pharma at that time.
And
Maybe
sir, it was relating to due diligence and reps and warranties.
Yes, that is also there. I can come. I mean, I'll try to come back to you separately. Yeah, an interesting thing.
Thank you, sir.
I can't come on that specific. However, there was the recent case in the US where HP had purchased Autonomy in the UK and viewed it itself as having been subject to fraud by the finance director and the CEO of the vendor. And they actually were able to bring the case in the US. So the finance director was held liable, but funnily enough, the CEO wasn't. He was able to say that he was a long way away from the transaction. So acting for the vendor, one needs to make sure that appropriate disclosures are made. But of course, at the end of the day, it's buyer beware. So the due diligence on behalf of the purchaser is absolutely what you want to be relying on. You don't want to be relying as a purchaser on reps and warranties, because if it gets to the point where you're chasing a vendor after the closure for non-compliance or breach of reps and warranties, unless you've had monies held aside, you may not succeed. And so, of course, you can take out, particularly as a vendor, insurance in many countries. in the event that there is a claim against you. But then, of course, your insurer may not pay if you haven't acted appropriately.
So if there are any no more discussions, can we open it for question and answer from any session which has taken place today?
No, one question I have still on due diligence, if you allow.
Yeah, please go ahead.
You know, because of these large scale acquisitions and due diligence playing an important part, as I was referring to Ranbaxy and Daiichi, will the experts share their point of views also on the liabilities that may come upon the due diligence professionals for negligence or overlooking any aspect in the due diligence?
Krantiji, this is a very interesting question. But if you look
Yeah.
at any sort of a due diligence, which I do or any of the panelists will do, we'll put in some disclaimers at the end of our report that we do not, we are not liable for this, we're not liable for this because of this. So disclaimers are put in, and there are some sort of assumptions that we need to put in there to safeguard ourselves.
Yes, it comes down to the terms of reference along the lines of what we put up earlier. So it comes down in preparing those to, as we've been so ably doing in this group, identifying what the purchasers' key plans are, and therefore the key assets that they want to acquire, so that one can have real precision in what one focuses on, and therefore and also the key liabilities that may be in the entity if you're buying the entity. If one has that pinpoint focus, and then is also keeping an eye out for any other significant liabilities, then one is narrowing the breadth of what one has to do, and then one is liaising with the client throughout, feeding back to them to make sure that they are working with you and understanding what you're uncovering, so that if they want you to investigate something further or not, then that is recorded.
Yeah, the most engagement letters, whether it is financial, legal, etc., also have a limitation of liabilities of clause. So it is not, I mean, you can't recover much from them. Actually, being a lawyer, actually, I'm also saying this, but there are always limitation of liability clauses. Yeah, I mean, it is always like, ultimately the buyer beware, the buyer has to do a significant brainstorming. And despite, I mean, I have also been part of certain things where the business call has been taken, despite the transaction not passing through any of the diligence. So we faced issues. So that is all known in the beginning itself. So the business call has to be recorded very properly by the sitting professional. These are common because the promoters have their own reasons, interests, and other things for going ahead or not going ahead with the transaction.
So, I mean, adding on to Ram's what he has just said, one of I mean, I'll not name the client, but one of the big fours did a due diligence on our client, and in the disclaimer it was written, please do not rely on this report for further action. So why the hell did we get the due diligence done?
Very large disclaimer.
So, sir, caveat emptor, if caveat emptor principle is to be applied, then
no, this is what Rams was just saying, that let buyer be aware of what he is getting into. It was not caveat emptor.
As proved as well, Yeah, I mean, that is why nobody was able to nail down even Daiichi also, because they knew. Because, and I have also seen something very different, actually. From particular level, the transaction becomes a friendly transaction suddenly, When it becomes a friendly transaction, I think there are many things overlooked. But the real problem arises when the valuation is not reached, when the numbers are not reached, etc. And then slowly the deadlock thing starts, and then there is an unrest starts, and it results in impairment in the valuation which will impact the financials of the holding company or the investing company. So those are all the real things actually, because it is, diligence has to be done in a very, friendly manner, but it's a very dispassionate manner, I would say.
If I may, I'd like to just add that at the beginning of the due diligence, once one has one's terms of reference agreed, which would ideally be a combined multidisciplinary terms of reference as far as...
Christopher, you're talking about the scope of work.
Yeah.
I'm just explaining the terms of reference is basically scope of work.
Yes. So if we have one combined scope of work, understanding which of us is doing what, then it's the lawyers who are negotiating with the vendor and their lawyers how the due diligence will be conducted. And ideally, we have a document at the beginning agreeing what the process will be, and ideally stating that anything that is disclosed by the vendor or the management on their behalf will form part of the disclosures and will be warranted as true and correct. And so you'll be familiar with the traditional questions and written responses, but also anything that is disclosed during oral meetings. So we try to have meetings where we will be going through the traditional list of questions focused around key assets and liabilities. And we'll make notes of everything that's said, and then we will give that back to them afterwards and saying, well, this is a record of what you've told us. And if we can get representation on that as into the reps and warranties, all the more helpful. I know that the accountants, they have lots of meetings with the client, and they put the output into their report, and then they'll often give the vendor and the management team an opportunity to comment on that report, which I think is an excellent process that we often try to emulate.
One question, Christopher. If in a due diligence report we are stating facts, okay, do we interpret the facts as well, or just we state the facts and let the interpretation be done by the person who is receiving the report?
What sort of
well, for example, let me give an example.
Yeah.
Someone you asked me to do a due diligence, a legal due diligence on a property. Who is the owner of that property? I go to the person, the registrar office, which actually takes care of transfers of properties, and see that Dr. Spedding's name is written on that specific file on that day. So my report should be saying that on this and this day, at this and this page, on this and this registrar's office, I found Dr. Spedding's name on the paper, which was on the top, right? I cannot interpret it as Dr. Spedding is the owner of the property. I can just write, yes, her name is there registered in her name. That's it. She has taken a loan or a mortgage or something that would be coming out in a different way from there, right? I know I'm contradicting myself because the mortgage is also coming out from the sub-registrar's office, but let's think on a different line that mortgage is coming out of say MCA record, right? So, and it's not normally mortgages are not registered in India; they are just left blank. So I feel that interpretation of the documents need to be done by the person who is holding the document. The due diligence provider can give you the facts, but not the interpretation of those facts. Am I right or wrong in this, Christopher? That's what my question was.
So as lawyers, what we try to do is we're working with the negotiation lawyers and team, and so it's our job to take the due diligence findings, particularly the legal, but also it's ideal if we can also liaise with the other DD teams to then provide recommendations to the negotiation team. hey, look, we found this issue, this property. It doesn't seem to be in the name of the company. We have to resolve that issue. And so that's what the negotiation team will then be doing, because they're facing the other side.
Sir, I will like to give my 2 bits to Mr. Gupta. When you do a due diligence, you have to apply your inference and interpretation out of it, and also advise the client of the risk associated arising out of that due diligence, and then the client deals with the risk in the appropriate manner, either with takes a business call, or there is a rap to that effect, or you make a disclosure and take the. So I think Mr. Gupta, as a due diligence professional, your duty is not only to see the document but also give an interpretation and the risk or the compliance associated with it.
I agree with you on that point, but it is not the interpretation that I'm talking about. It is the opinion of myself, understanding that document, and in case I have, even the document is correct, but I have a feeling that it might be a forged document because of certain things that I have seen on the document. My opinion might be not to go through with that specific deal because of
Sir,
certain
you may
issues.
qualify your.
No, I will never qualify it in a report. It would always be verbal.
But see, unless you disclose to the client the risk associated with such document, the purpose of due diligence may not be fully achieved. But I respect what you say.
But agree. But when you are there where the documents can be replaced and paused, we have seen this in many cases, that documents are not what they seem like. There are cuttings on the documents. They are not, I mean, last 3-4 years, the digitalization has taken place, but prior to that, it was a very difficult job to go through different sort of compliances. Let's take that same example of a property due diligence, where the mortgage needs to be found out. So in one of the matters that I was doing, we did due diligence on the property from 12 different departments of the government. There was no mortgage anywhere. No mortgage anywhere. Not even the MCA, not with the CRISIL, the other agencies, not with the sub-registrar. And that was used as a leverage with the bank to settle with us. I mean, the person from whom we were buying the property, he settled because we bought the property assuming that there was no charge on that property, and ultimately we found that there was a charge on that property. It was under a mortgage which was not registered, and the bank had to accede to our wishes of a settlement.
Sir, I will say someone from panel only said that we have to act as dispassionately. So if I see this dispassionately, the problem that you are saying, I as a due diligence professional have done my duties. Now, whether that there is something beyond the documentation, I cannot comment upon it. It is on a case-to-case basis.
You are correct. See, you cannot comment anything which is not in your knowledge.
Yes.
Right. You are right on that. But the point is that what you were saying, that to infer and to opine on a certain thing, I don't think that would be appropriate in any sort of a situation. Yes, Christopher. Yeah.
Yes, I'd like to just add that one of the questions that I asked the purchaser when agreeing the terms of reference of the due diligence is whether the due diligence is purely defensive, i.e. they want to make sure that they're getting the assets that they require and to identify the liabilities, or do they wish to become even more aggressive and use the due diligence to drive the price down? So one can always find fault, as we all know, and then it's a cost of mitigation. And as we all know, the cost of mitigation could be this amount or it could be that amount, depending on who you're going to use to undertake the mitigation. And so if the purchaser says, I want to get as much money off this price as I can, then one can be working to be putting as much into this bag as possible. And we, for instance, we're involved in one transaction where we got 10% off the price based on liabilities that we knew were not going to necessarily become actual liabilities, but we were able to argue that there was such a potential for those to manifest that the full potential liability should be taken off the price.
Any more questions? Because we have reached the end of our time limit. It is now exactly 5 o'clock. We can take a couple of questions if somebody has on all the panels that we have done today. Anyone, or should we just close the webinar now? Anjali?
Thank you, sir.
Thank you. Thank you. Anjali, you're there?
Thank you. Thank you, everyone.
Thank you. Thank you, everyone, for your presence.
Thank you.
Thank you, everyone.
Thank you, everyone, and have a great evening.
Thank you. Thank you, everyone.
Bye.
Thank you.
Thank you, Rocky sir, for organizing such a nice and wonderful session.
Thank you.
The
Anjali.
session was very outstanding. Sir, you are requested to kindly arrange to provide the PPTs for all the panel speakers.
Okay. Okay, ma'am. Thank you.
Thank
Thank
you.
you.
Thank you very much. And bye,
Thank you,
everyone.
Linda.
Thank you. Bye-bye. Bye.